Splice updated their terms of service. This is the updated version, and it still says, at the end of this video, I'm going to include the video that Splice filed its copyright strike on because they didn't like what I was saying. One of the things that I do on this channel is I expose music businesses by looking at their contracts. Now, their contracts are what are called terms of service, right? You sign terms of service when you sign up for any website, for example, a music distributor, for example, Splice. And so there is a contract that you look at. And so what I do is I go through, I look at the contracts and I expose their terms so that we all understand what we're signing, because you cannot negotiate the contract. You just get to sign it and that's it. Now, in preparing for today's video, couple of things. Number one, we just moved spaces. And so if you're like, Krystle, your office looks a little different today, we're in the process of getting set up. But then number two, in preparing for this, what I'm going to do is go through, because we have a big update. That big update is that Splice updated their terms of service. A part of my question that I have as we're going to be looking at the updates, because I know how to run what are called red lines. So I can see all the changes that have been made into this document. And I'm going to show you guys what those terms are. Now, I needed to do a little bit of a recap in preparing for today's video because I go, well, there were a lot of things that we pointed out from their terms of service and we go, look, this isn't good. We don't like these things. It's not clear. And at the top of the list is this issue in regards to if you use Splice, you download samples, sounds, loops that you then can incorporate into your music. And as we were going through their prior terms of service, I go, well, it's not super clear about your rights to use those sounds as part of your music in different situations, including if you ever actually sell your music. Now, let me be clear. When I say sell your music, I'm not saying just to distribute it and stream it. I mean, when you actually sell your music catalog to someone else who's going to own it, which is something that our artists do and our music producers do later on in their career, because your music catalog is very valuable. And so my inquiries, I go, well, I do this. Last year, we sold $9 million of music catalog. And I know that when we go to sell music, the samples that are contained in the music have to carry with the sale to the new owner of the music. And so as I went through their terms, I go, well, can you do that? And some things were unclear. Okay. And we had questions. As I was kind of prepping for this, there were some videos that I did just talking about how everything just kind of went sideways. My show producer and I, otherwise, we're fans of Splice. We've used Splice, for music creation, all this kind of thing. And as I was going through and just pointing out some of these inconsistencies in their contract, it resulted in them sending me a cease and desist letter. It resulted in then getting on a phone call because I'm like, look, let's just get clear on this, because they're like, you better take down your videos, you better correct yourself. And I go, I don't think I need to correct myself. I think we just need to get clear of what you need to update. And I hope you guys make those updates. And at that time, they had said, yeah, we're going to make these updates. I was like, great. And then after that, I released a little update video and they didn't like what I said and they filed a copyright strike on this channel. So look, the point of this video is not to just kind of go back through and recap all of that, but as I actually went through and kind of recapped everything, it was a little traumatic, to be honest, going back through all the content again. What I honestly do want to do today is I want to look at the red line. I want to see the updates that they made, and hopefully they have addressed all the concerns that we asked them to clarify, right? As users, as artists, as musicians ourselves. So that was our request. Things kind of went sideways with the copyright strike. They did end up removing the copyright strike. When I got an email from the CEO, there were no apologies or anything like that. But you know what I'm saying? We were kind of, we're in a better place. And so now that there are updated terms of service, I go, look, I hope they made the changes. So we're going to go through. Let's go. So this is what we call a red line comparison. Let me see if I can even make this bigger for you guys so you can see it easier. Here we go. All right. So I ran a comparison, and the comparison is between the original version that we looked at, which had May 13th, 2024 as the last updated. And then they just recently updated this, right, as of August 22nd, 2024. Now, I said this in the terms of service review that I did last time, which was very extensive and detailed and all that good stuff. And I just go, look, I've looked at like thousands of contracts, and a whole lot of them are terms of service contracts. And I go, just in my experience, also representing a lot of music businesses, I have found that when companies update their terms of service, it's usually for a number of reasons, one of which could be that they're having some kind of legal problem. So they update their terms of service in response to something so that hopefully it doesn't happen again. And then, sometimes they also just update them because they've had some change in the services that they provide. And so they just need to reflect that. So did they make these updates following our many requests? We'll see. Depends on what they actually put in here. So I'm going to do two things, which is as I go through, I'm just going to point out some of the stuff that we looked at before, but then also highlight, the stuff in red is anything new that they've added. All right, so as we go through, they go, look, this is a contract and it's between you and us. You're using splice.com. So please be aware, there's a whole bunch of stuff later on in this agreement that has to do with like arbitration and stuff, affecting your rights. And then just so you guys know, when you're doing contracts, the reason why they put this language at the beginning of the contract is because it helps with making the contract enforceable. This contract is 30 pages. So one of the legal arguments that we have sometimes is that we go, well, they said this thing, this paragraph about this really important thing on page 29 of 30. So like logically, you probably didn't see it, you probably didn't know it, you probably didn't read it or whatever. So that's why they do it. They put up, some of the most scary stuff, we'll call it, in caps, it's bolded, it's first, and they do that just to raise your attention to it so you can't argue anything about it later on. All right, so this is all the good stuff about, you have to be 18, there's age restrictions. We're not going to go through all of this. Again, I just really want to focus on what was updated and then our questions that we had in regards to your usage. They talk about, basically everything that you use, from presets, loops, stems, one-shot, sounds. This is what we define as sounds. You get to use our samples by purchasing credits. We did a separate video in regards to this because we're like, it's really not clear about what happens to the credits when you, let's say, stop paying for your subscription, right? So you music producers out there, you guys will be like, I have like thousands and thousands of credits and I don't want to stop paying because I don't want to lose my investment. So this is one of the first updates that they made. So we're here in section 3. And then for context, let's go back. So unless otherwise indicated, through the service, previewing or auditioning any sounds, organizing sounds into your personal collection, and saving a sound to your sounds for future use. In each case, without downloading a sound, generally does not require a credit. Okay, once you redeem a credit for a sound, unless otherwise indicated through the service, you may re-download that sound an unlimited amount of times from the Splice sounds using additional credits as long as, and then they said, well, and I guess that's a little bit of a typo, so just maybe they need to take that out. So take out one of the as long as you have an account. So you may re-download the sound as long as you have an account. And that was one of the, questions. We're like, what happens if you don't have an account? If you stop paying, does your account get terminated? And if it's terminated, is all of your credits, do they get wiped out? So here they go, all right, so access is one thing we're going to pay attention to because it goes, well, as long as you have an account. What happens if you no longer have an account? Well, we know that you can't go in and re-download the sounds. Okay, that's fine. All right, so let's get into section 3.1, license and ownership terms for Splice sounds. This is some of the most important language in this contract. Your use of our samples. Sounds are licensed and not sold to you, right? Because they are licensing the samples to a whole lot of other people too. Upon your download of a sound, you may obtain a copy of the license granted to you for that sound. And we talked about this. So here's the thing, guys. I'm gonna give you just a little bit of a nugget. At the end of this video, I'm going to include the video that Splice filed its copyright strike on because they didn't like what I was saying. After that whole thing happened, I released additional videos and I addressed it, but I actually show the emails between Splice and myself. I show one of these certified licenses and I go through the whole thing because truthfully, what I was trying to do in that video was to show you guys how it works and to make sure that if you are using this platform, that you can get the certified license. This is how you get it and that kind of thing. At the end of this, you'll have an opportunity to actually watch that. But for now, let's focus on this. So the certified license, evidencing your download. Okay, you can obtain the certified license by going to your account. All right, we get all that. And then this is one of the things they changed. For purposes of clarity, you may access your library so long as you have an account. There it is again. That's interesting. So they're wanting to clarify that your access to get the sounds is based on your account still being in existence. So then my question is, well, all right, so what triggers termination? What triggers you losing access to your account? So we'll get to that. All right, new recordings. So any new songs that you make. Subject to your compliance with this agreement, we grant you a non-exclusive, non-transferable, perpetual right to use sounds you obtain through Splice sounds in combination with sounds in music productions to create a new recording, hereafter each a new recording for commercial and non-commercial purposes, except as prohibited down below. They're killing me. Here we go. This was the whole problem. We go, subject to your compliance with the agreement, we grant you a non-exclusive, non-transferable right to use the sound. So, the reason why I pointed this out on the first go around is I go, if you're saying my right to put the sample into my song, I can do that. You just said commercial, non-commercial. I can put it on music streaming platforms. I could do digital downloads on my website. Great. But when I got on the call with their legal team, I go, the problem is that you said it's non-transferable. So meaning if I go to sell it, I can't do that. And I go, I just want to be clear because as a company, if that's what you're saying, it just needs to be in the agreement. That's basically what it says. So I goes, if that's what it's supposed to say, good to know. And then I can tell my audience, right? And specifically in regards to selling your catalog, I want to distinguish that because I'm not saying to distribute for streaming. I'm saying when John sells his song to Jane, who's now going to own his song, which a lot of you do. And even if you don't do it now, at some point with your career, if you build up enough of an audience and you build up goodwill and all this good stuff, you can actually assign for ownership to be transferred to someone else. And so I go, that's problematic because pursuant to this agreement, it says non-transferable. And so when I spoke with their legal department, they're like, no, we want our creators to know that they can do anything with the songs that they create. We don't want to impede them in any kind of way. And on the call, I was like, oh, that's great. And in fact, that's how it should be, in my opinion. But, it's good to know. And so in the video that they took down, I gave you guys this update or whatever. But here's the thing. This is the updated version, and it still says non-transferable. A Music Attorney is your #1 legal resource for artists, producers, and record labels. Get contract templates, one-on-one legal advice, free master classes, and everything you need for your music business. Go to topmusicattorney.com. My problem is that there's just been now an inconsistency of that I actually spoke to their legal department and they told me a different story. And they've made updates, and the updates that they made didn't substantially or materially change this. So meaning it did say already, it said down here before, right? So you see it was crossed out. So it used to say, you're okay to use the sample in your new song, including for commercial purposes. So that's what this says. All they did is they just moved it up here. So they never address the actual issue, okay? So we go on and they're like, well, in regards to other stuff, right? So if you use your stuff in video games, film, television projects, again, it's non-transferable. What that means practically is that you just can license your stuff. And that's great. That's super great for a very large majority of artists and music producers and music creators, because they are creating music for themselves. They might license, the rights to someone to remix their music, and maybe they will never actually sell their music catalog, right? So meaning someone else will take ownership of it. But this creates a problem on the back end because then me as the attorney representing John I go, there's a sample in John's song. So you're telling me John has to go back 10 years and find the session file to take out the sample. And maybe the sample was the entire instrumental loop because or bet I should say, because the loop just played over and over and over and over. So what we'll do is just try to stay factual about this. As you guys can see, this is a little frustrating for me, but that's what it says. So on the list of updates that they did make and stuff that they did not make, they did not adjust that language. And even when I was on the phone call with them and I go, guys, if you're telling me that it's okay for someone to sell their song outright to someone else, it has to say that. You can't have someone signing a contract that says the opposite, because it exposes them to all kinds of potential issues and liability from Splice later on. Non-transferable seems to mean that once you have bought the use of the sample, you can't decide to give it to someone else, whether you have used it or not. Each person must buy use of the same sound. Yeah, basically. So, and again, when I go back to the music catalog sale, we have to produce the license of the sample as part of the sale. So we talked about this earlier. We're like, hey, look, they have this certified license. I'm like, the certified license says John has a license to use this sample from Splice. But what they're saying in the contracts are you can't give that license to the new owner. So I go, that's where this breaks down. That's where you are not setting the artist up for success. But this isn't the only change that they made. So let's see what else they did in this paragraph. So they go, it's okay to use your creative work, right? Your new song in live performances, vlogs, loops, remixes for non-commercial and commercial purposes, except as provided down below. This means that you can modify. This means that. So I like that. They provided clarification because this means that you can modify, reproduce, publicly perform, distribute, transmit. I'm looking for the word sell, communicate to the public, sublicense, or otherwise use the sound as embodied in the creative work. Now, here's the thing. In their defense, the reason why maybe they don't want to add in the word sell is because the following paragraph is this big paragraph of all the stuff that they say you can't do. They're like, you cannot just take our samples and repackage them together and sell it as your new sample pack. Of course, that makes total sense. But you can absolutely distinguish and say, you can sell your sound recording containing the sample. That is a few words that could be in here if that's really what they do and if that's really what they're okay with. But they didn't make that change. So I don't understand why. All right, so they also added you or any applicable third party, contributors, or artists engaged by you in connection with the creative work will own any original contributions made to the creative works that are not comprised of sound. So again, they're reiterating you do not own the sound. That's okay. So example, if you had added vocals, if you had more instrumentation, for the avoidance of doubt, you will not own the sounds. Okay, that's fine. Drop says, say an artist makes a song using Splice and another artist remixes that song, what happens there? So it does say that a sublicense is okay. If you tell someone that they can remix your song, you're okay according to their updated terms of service. But here's one thing I do want to point out for you music producers using this. When I was talking with Splice Legal, again, they were sharing with me some of their music producers use the samples as sound effects that they're composers. And so they're like, yeah, there's so many situations that come up. And so we need to kind of work with these creators to make sure that they have these samples cleared for what they're doing. And so, again, I just go, okay, if that's the case, and that's what you're telling me, that needs to be in this document, but it's not. Right here, it goes, these are all the things you cannot do. It's very long. And again, some of it's super obvious, like you shouldn't just, take their samples and rent and lease, free sample pack. But right here they go, you may not sublicense the sound in isolation as sound effects. You cannot use the samples as sound effects. They made updates, and as we're seeing, they made updates as it relates to the things that we pointed out, the things that we talked about, but I don't know where the disconnect is happening. My whole intention is to try to protect you guys and set you up for success, because I can't even tell you, just this last week, I'm a real law firm owner, and we have 2 separate cases where there's an issue of a sample that is in the song, and the song has become a huge hit, and now we have to go back to try to unravel the mess that has happened because the sample wasn't supposed to be properly in the song, or the song was now being used in a new kind of way. Or in this case, I'm just like, again, in the instance that there was a music catalog sale, the sample is in the song. So you're telling me to just explain to me what should happen. Does my client now need to go back to you and ask you for a license? And in fact, I have an answer for that later in this document. We'll talk about that. Or are they in breach of contract? You're going to sue them? Why don't you want to put in that is okay for your creators to outright sell, to assign to another person ownership of the song that they created containing the sample? Now you might argue and just be like, well, it's because the new owner might take it and not know that it's our sample, and so they take it out and they're selling it all by itself because you, the artist, signed the contract, so the terms. Maybe it's something along those lines, but that's not even a good argument, because it also says you can sublicense. So you can, in fact, let someone else through a license remix your song with that sample in it, do all kinds of stuff. So again, what am I missing here? Please help me out. All right, let's keep going on this. So cruising along, this is a very long document, so I just want to try to make this as efficient as possible. So in regards to cancellation, you may cancel your payment plan at any time prior to payment of the final installment, after which you will no longer have access to third-party plugins to be able to use purchase presets in new recordings and creative works. To cancel your payment plan, please visit the billing section of your account. If you cancel your payment plan, then your cancellation will be effective at the end of your then current billing cycle. Okay. And then they crossed out, if we suspect that you are incurring excess or fraudulent chargebacks, we reserve the right to cancel your payment and or account. So there's one reference to basically terminating your account. And they replace it with, if we suspect, they just put all in caps. If we suspect that you are incurring excess or fraudulent chargebacks, we reserve the right to cancel your payment plan or your account. Okay, so they just wanted to make it nice and big so you could see that. Okay, minor, formatting stuff. They added numbering. That's fine. That's fine. Now, we are about to get to this big section called assignment, but they also updated just references to some of their other agreements. Email, okay, nothing too crazy over here. Termination. You may terminate your account and the agreement at any time by either accessing your account or sending an email to us at support@splice.com. Okay. For the avoidance of doubt and for purposes of clarity, if you choose to terminate your subscription, you will continue to have access to your account. So I read that. I'm like, oh, that's great. Unless such account is terminated in accordance with this section 12. And I'm like, oh, wait, what? So I go back up. I'm like, okay, this is section 12. So they go the term, automatic renewal, termination. I'm like, well, we just read. So again, for this update, it's confusing because it's like you just said you will continue to have access to your account, because this is a big concern that Splice users have. They're like, if I terminate my subscription, what happens to all my credits? Can I go back and like re-download the stuff that, you know what I'm saying? And so the addition is not actually clarifying anything. And maybe I'm misreading it. They're like, unless you terminate in accordance with the section that we literally just read. Let's get to the assignment. So this is down on page 23. So it's quite the cruise. I've read all of this. So going back to my assignment, how do we assign this? This is what their contract still says. I pointed this out to their legal department. The agreement and your rights and obligations hereunder may not be assigned, subcontracted, delegated, or otherwise transferred by you without Splice's prior written consent, and any attempted assignment, subcontract, delegation, or transfer in violation of the foregoing will be null and void. So look, what I'm going to do is I do want to just give you guys the context of letting you see the video that was taken down right after this, but I'll just end with this, okay? That assignment provision right there expressly says you cannot assign your rights under this agreement, and that would be in conjunction with the sale of a song and outright transfer. I addressed this with their legal department. I was so excited to see that they had made updates to their terms of service and they addressed many of the things, sort of, that we had discussed. But all of this is ultimately just to make sure that whatever Splice wants to do as a separate, existing, private company, that whatever they want to do is fine. My problem is I go, well, this is not setting artists up completely for success. Here are some problems that I can practically see being a practicing attorney, helping artists on the tail end of their careers and helping them to sell their music catalogs. And then based on my communications with Splice directly, they told me a couple of different stories. We're so artist-centric. We, support our creators, and we absolutely let, artists sell their music. And then they finally updated their terms of service and they didn't reflect the things that they told me. So you guys can watch the video now. Leave your comments down below. I'll see you on the next one. Big thing that we do on this channel is we expose music businesses and specifically the contracts that you sign when you get on their platforms. We recently did a video talking about Splice and their terms of service. We went through, I always do my thing. And the reason why we use the word exposed is because we're going in and looking at the actual terms and telling you what do they say. Because for many of us, when we sign up on these platforms, we don't read the terms. And so taking the time to go through and just kind of point out some of the stuff that might be concerning, that might be good, is what we do here. And it's actually what I do as, an entertainment attorney, as a music attorney with 10 years of experience in law. And I've been in the business since I was 4. I just love it. All right. And for those of you who are nerds like me, I appreciate you being here. So we did the terms of service and I got an email from Splice's legal department. And as I was thinking through how I kind of wanted to do this, I figured I would walk you through what this looks like. Because, as an entertainment attorney, I deal with a lot of like entertainers and musicians and this kind of thing. And, if you're going to say something on the internet, someone might see and they may or may not take an issue with it. And I wanted to share not only what the email said, but kind of what happened, because there are updates. And this all happened starting as of yesterday. So things have been moving very quickly. So if you're interested, keep on watching. Let's start with the email itself. All right, so I have redacted. I have taken off specific people's names and emails just for purposes of privacy, but I of course kept, Splice Legal just so you guys can see it's the real deal. So here's the email. Krystle. Hi, Krystle. I hope you're doing well. A user brought to our attention the video that you uploaded. This was last week. That you uploaded to your YouTube channel yesterday. They are a longtime Splice user. who found the information contained in the video to be very confusing. All right. So someone watched my video, and in fact, we did it last week, but I think we did this separate segment yesterday. Longtime user reported the video, let us know. And we found it very confusing and asked it to clarify a few points. All right. It's, of course, not helpful that we now have users who may be confused by the content of the video, which does contain quite a bit of misinformation, including seemingly classifying Splice as a music distributor on more than one occasion. So I would like to take an opportunity. So in the very beginning of my video, I mentioned that I do the review of terms of service, which is the contract that you guys sign, and I made a joke. I understand that my attempts to be funny sometimes won't go over, but I made a joke at the beginning of the video, and I'm like, here are the things we're looking at in, this contract. We go, do you own the samples that you download from Splice? Can you use them without restriction, or are there restrictions? Can you use it commercially? And also, is Splice taking your royalties? That was a joke. For those of you who do follow me, we've been on this saga with the distributors because all these music distributors are taking your royalties. They're being unfair. It's just insanity. To clarify, I am not trying to compare Splice and say that they are a music distributor. If at some point they decide to do some kind of music distribution, we will let you know. That is not what's happening here. So, wanted to clarify that. I trust it was not your intention to misinform or confuse our customer base. That's good. However, it seems that has been the result. Essentially, with the misleading and clickbait nature title of Splice Exposed. I'm not quite sure what was being exposed here, as you say yourself, that a lot of our terms are commonplace and boilerplate. I'll come back to that. Aside for, of course, our indemnification provision, which seems to be your main critique. Though you fail to mention that this is found in almost every business's terms of service. All right, so what they're talking about, and when we say boilerplate, we basically, this is our lawyer speak of just there's certain language in contracts that you see over and over and over. And that's why I make a point to point these out to you guys, so that if you do happen to see just one video or maybe two videos, we go through and I'll be like, hey, here's something that you're going to see in a lot of your contracts. And then I give you something you can do about it, which is when you see this, this is what it means. This is why it's no good for you, or why it is good for you. Usually it's no good for you. And I'm like, so this is what you do. So I try to help to, just educate you guys as we go, so you can, think like lawyers. Now, again, the Splice Exposed thing, right? It's just what we do. It's just the segment that we do over and over with the terms of service, because there's some of the things that aren't very pleasant in these agreements that we go through, and you guys are very surprised. So that's why we call it that way. We'd hate to have to issue a takedown notice to YouTube due to the inaccuracies. Oh boy. We love reading terms of service too. However, in the spirit of making sure our users are able to use our platform correctly, we ask that you do either revise or publicly correct the misinformation and or causes of confusion we discovered throughout your video outlined below. Please note that all timestamps are approximations. Now, here's the thing I was kind of curious about, and I didn't get clarification on this. I should have. My understanding is that the function that YouTube provides for issuing takedowns is related to copyright infringement. If there's other stuff, trademarks, right? There's that kind of thing. But for inaccuracies, I'm not familiar with that. I'm curious. So if you guys are familiar, drop a comment down below. Okay. But typically, the reason why people get into trouble with YouTube takedown notices is because you can't just file one. It has to be a copyright infringement kind of situation. Unfortunately, our freedom of speech, people can say stuff on the internet. People say stuff about me all the time. As much as I'm like, oh my gosh, he gets to just live on the internet. But in any case, let's go through, because here's the thing. Anytime, because I'm not perfect, if I ever say something that is inaccurate, if it's a misstep, if it's whatever, my whole goal of this channel is to help you guys. And so if I say something that is wrong, I will absolutely correct it. One thing that I was really excited about, and I'm going to show you guys my response to their email. But the thing I was really excited about is that they actually reached out to me. Now, obviously, the way this is going is, they're telling me to do stuff. I need to take down my video. I need to issue, corrections and all this stuff. But I do appreciate that they reached out. All right. So I digress. Let's go back. All right. So here's a list of the problems that they took. So at 1:30, they say that I failed to disclaim that Splice is not part of any legal process, that I state that would cause companies. So I say in the video that basically, and I'll explain this, but I go, basically videos usually, or not videos, companies usually update their terms of service when they're dealing with some kind of claim or something bad's happening. So they go, you're saying this, and we're not part of a lawsuit, we're not part of a claim, we're not part of a settlement. Splice was not part of any of this stuff, and it's inaccurate to say this is a main reason as to why companies will update their terms of service. All right, so when it comes to my experience, because I represent everybody, I have done this for 10 years. And just in my experience with these big companies, that is usually when we make changes to terms of service after we've been around forever, like in their terms. In fact, let's go to them, right? In their terms, which they first put together, and they have this on the document, right? They go, they've been effective since 2014, and they were last updated in May of 2024. So at the beginning of all my videos for the terms of service, I always make a note of like the last time a company updated their terms. And the reason is just because I'm like, when all my clients get into trouble with something or they're dealing with this brand new issue that's come up, like that's a pretty big reason why terms of service get updated, because we want to like stop the new issue that's happened. But they clarify. They're like, we're not involved in any lawsuits. Great. I don't know. All I can do is just offer what my experience is. But they did clarify in this email that they're not involved in any lawsuits, and any recent updates were not made because of anything like that. More common reason to update your terms of service is because certain portions of the services have changed and clarity is needed to better serve the customer, as in the case of Splice, and could learn there's more things, and you can go back to Wayback Machine, and we talked about this. So I did this because it's been a super long time since I've reviewed their terms. But anyway, they're right. You can look at the Wayback Machine and all the different versions. We updated our terms recently to account for new create feature and the discontinuation of certain other features such as studio, a discontinuation which applicable customers were notified about months ago. We also added clarification points, the frequently asked questions. We monitor and answer daily. Okay, that's great. I have no problem with any of that, and I'm very comfortable saying that my comment was not to somehow imply that they are involved in lawsuits and that they're a naughty company and there's all kinds of bad things happening. I don't know what's going on with them. Okay, but that's what they say. Good to know. Moving on. They say at 12 minutes and 40 seconds in my video, there's a mischaracterization of what a transferable right is, which is surprising given and this made me laugh, given your business as an entertainment attorney representing musicians and producers. They're very surprised about my mischaracterization. I'm like, did you just call me an idiot? What you then describe when you discuss remixes is a sublicense, not a transfer. A transfer of rights would be the right to the entire sound. Okay, guys, we're going to talk about this. I'll show you exactly what we're talking about. That is transferring the certified license that the subscriber obtained to another person who may be a non-subscriber of Splice. This is not permitted. The rights holder is the subscriber who downloaded the sound in accordance with the terms. This is distressing as you imply that our users are limited in their creativity by stating that they cannot sublicense, or as you say, transfer their music to others if it contains a Splice sample. This is wholly inaccurate. This was a pretty big point, okay? Because I go, I don't want to create confusion. That's for sure. And in fact, related to this point, it's so important that I responded, and I'll show you guys my response. But let me just give you context again of looking specifically at their actual terms, okay? Because that's all we did. My job is I read the four corners of contracts, and I'm like, this is my understanding, and without any additional information, this is how I'm taking this. So we went to 3111, and this is kind of what we were talking about. So we go, subject to the compliance with the agreement, we grant you, Splice user, a non-exclusive, non-transferable, perpetual right to use sounds, right? So the samples that you get from their platform that you obtain through Splice Sounds in combination with new recordings. So your new music, you can put their sample in your song. And I go, okay. And then we got hung up a little bit because I go, well, it's non-transferable. And there's lots of ways that this can be interpreted. Often with companies, what it means is that, and this is what they said in the email, right? They go, well, you as the user, the subscriber, we're giving you the right. So you can't then be like, hey, Johnny, here you go. You get to have my rights. And I go, generally that's how this works. Okay. But nonetheless, because I, do sales of music catalogs. These are the things I really, really scrutinize because I go, we just want to make sure that after you use the sample in your song, you don't have limitations. And so that's the framework that we were kind of going through this. And I go, I don't like those words, but let's keep reading because having context is really important. So we go on, and this is why I was like, oh, I like this. So then it goes on to say, this means that you may modify, reproduce, publicly perform, distribute, transmit, communicate to the public, sub-license, and otherwise use the samples as embodied in your new song, including for commercial purposes. And so this was all great. We're super excited about this. But I still kind of had this ongoing kind of question mark. And I'm like, but it doesn't say you can sell it. And so I go, are they just giving you a license? So you just get to use it to then let people use it, if they're remixing, if you're putting it on music platforms. And so I go, look, it's really important that we just understand ultimately, what is the company trying to do? They're trying to get you to use their sounds. They don't want to mess up anything for you. So I kind of said this throughout the video. All right. But this is what they were talking about in the email. They're like, you're causing confusion. You're making people question about the transferability. And I'm like, I hear ya. I'm confused. I might be an idiot. Okay. So we need some clarification here. So I responded to their email. And this is what I said. All right. So here's my email. This was yesterday at 4:32 p.m. I go, hello, Splice Legal. That's really how I wrote it. Hello, Splice Legal. I find your email very refreshing and very much appreciate you reaching out to clarify these items. Would you by chance have a few minutes early tomorrow, so today, to jump on a call so we can further clarify the non-transferability of rights issue? Also, would you be able to send me an example of one of your certified licenses? Okay, we'll talk about that in a sec. I have a show, we're going live, and so I'm planning to do a Splice follow-up. So it would be great to touch base. I'd be happy to clarify any needed items to my audience. It's helpful getting additional information directly from your company, since I otherwise just have to go through what's contained in the four corners of your contract. Thank you so much. And so guess what, guys? We got on a phone call today. And I gotta tell you, I told the attorneys, I was like, basically, I don't know how this call is gonna go, but I'm like, I am delighted. And I so appreciate the speed at which Splice's representation followed through to even just chat with me. But think about it, from seeing the video, getting some email from one of their Splice users who saw my video, them reaching out to me being like, hey, let's jump on a quick call. I have a video that I'm gonna do. And them actually jumping on a call. And I just started with that. I just go, look, of all the music businesses that I've been covering, I just really appreciate that you guys did this. And so thank you very much. And so I go, I need to understand this because there's some, issues that we're having here. I'm like, look, it says here in your agreement, commercial purposes, right? You even talk about, in instances of the non-transferability, but using the music for commercial purposes and the videos and games and all this stuff. And I even brought up that way later in the agreement, I just go for consistency purposes. I go, when it literally goes to do you see how far this is? I mean, come on. When we get to the assignment language, which I go for purposes of selling the music, do you see how far we're going here? All right, here we go. On page 21, assignment. It says, the agreement and your rights and obligations hereunder may not be assigned. May not be assigned. Subcontracted, delegated, or otherwise transferred without Splice's prior written consent. And I go, okay, so once again, with the whole I just need to make sure that my clients, my artists, my producers who are using this service just have an uninhibited kind of right to do what they need to do. So going back to the certified license, all right, I had my producer go in and do a little screenshot of what this looks like. For you Splice users, you know all about this, but I thought it would be helpful to show this because he does it, I don't. So this was new for me. And I also had him download one of these certified licenses so I can show you, practically speaking, if you're worried about any of this stuff, what they told me, and then also what it looks like. All right, so you play the little sound. You can go to the three dots. You see the little three dots. Generate a proof of license. Put in the legal name. We're doing Top Music Attorney as a quick little test. The producer name or artist name, TMA. Generate the license. Great, here we go. And now we're going to download the license. This is what the license looks like. Okay, and we'll go through it. And then the actual sound is hyperlinked in the license itself. I was like, oh, this is so great. Now, one of the things that was kind of expressed to me, for those of you who maybe didn't even know about this, or that you could get it, or that it was needed, that's why I wanted to just like highlight it. And I brought this up to, Splice's legal team, and I go, look, for purposes of what we read in your terms of service, what it said was that once we like terminate the contract, that we no longer have access to our accounts on your platform. I go, that's what it says. And they go, oh no, actually, you keep your username. One of the attorneys was like, I think that you can, maintain access for, 5 to 6 years. And the other one's like, oh no, it should be like just uninhibited. But they're like, either way, you can reach out to us anytime. And we have a copyright team managing our email to help you, because if you have problems, we want to help you to make sure that you don't run into issues with your actual music. Okay. So they go, for purposes of accessing those certified licenses, practically speaking, because there's two things that are happening here. One is, look, and I said this to them, everything you're telling me and clarifying, because when we got back to the transferability issue, I go, just break it down in layman's terms, right? Are you saying that it's cool that me as a producer, I put your sample into my song and then I can sell it, I can license it, I can sub-license it, I can do anything that I want as long as I don't do the things that you talk about as, the excluded things, which is I can't take your actual sound and resell it. Be like, hey, here's my little sample pack of like all the samples that I got from Splice. I can't do that. But as long as, and this is what they said, as long as it's in my song, my creation, or whatever, and it's not violating any of those things that they say don't do, I'm good to go. And I go, that's great. So I feel comfortable sharing that with my audience because it's coming directly now from the source. But I go, would you guys be willing to update your terms of service? I go, because, we had to go through a bunch of hoops to get that clarification. And I go, it would be great if you could just clarify, add in a sentence. Okay. Because if I got confused, someone else might get confused. And they said that they would. Now, here's the thing. I know that they're going to watch this video. And I would like it if our audience would give some feedback. Leave a comment down below if you want them to make the updates to the terms of service for purposes of just clarification. Because something that they really stressed was just that, they are all about the users. They want to make sure that everything is super clear, that when they make these updates to the terms, it's usually because they're changing products and things like that. And they go, we want to be transparent. We want to make sure everything is super updated and that you guys are protected. And so if that's the case, I think that would be a real hero moment for Splice if they actually update those terms of service. And I look forward to reviewing those updates when they're done. One of the other things that kind of came up that I thought was interesting to share with you guys is that they go, not all of our users are music producers. And they go, we have these big companies, I won't drop names, but we have these big companies who use our sounds as sound effects. So, there's all these variations of how people are using our stuff, because now you don't even really have something that's contained within like another song. It's a sound effect that's kind of contained in a scene. So they go, for all these reasons, we do try to make stuff as like flexible as possible. And that really is our intention. So, as far as dropping that comment down below, do we want to see an update on the terms of service? But then also for the content ID thing, this kind of came up because, one of the complaints that I had seen from music producers over so many years was just that they would have their music flagged on, let's say, YouTube, and they go, it got flagged, and it's because it has a Splice sample in it. So I don't know, am I really okay to use it? Is it cleared? Is it whatever? And so they did mention that Splice typically registers and puts all of its sounds into content ID. So, from a practical kind of, standpoint, maybe that's what's happening. But in any case, what we can comfortably say is that we're going to get these certified licenses, and I have a copy. So let me go ahead and show you really fast, because this was helpful for me to see. All right. So the certified license went to Top Music Attorney. All right. So it goes, Splice holds the legal rights necessary for further distribution and has licensed such content to Top Music Attorney on a perpetual, royalty-free, non-exclusive basis. The use of the following content is in accordance with our terms of use, which we've now reviewed, by Top Music Attorney, and shall therefore not constitute a valid basis for a copyright infringement or demonetization claim by a third party. And then it goes, the content licensed is this. And so then it hyperlinks and we can listen to the sound. And then it goes, please, take a peek, make sure you are doing your thug within our parameters. All right, if there's any issues, reach out to copyright@splice.com. So one thing, just as a practical item for you music producers, is that you do want to download your certified content licenses, because what the contract did say was that you could, get the boot from your account. Now we have, differing information from the current representatives, right? So we'll go by them, and they go, no, no, no. And even if something happened, you could reach out to us, and we will go through our Wayback Machine, right? And we'll get it for you. So we want to make sure you just, you're good to go. But nonetheless, I would just say, please make sure that you are downloading these content licenses so you don't have to go through extra steps. If you do get a claim from a music distributor, from a label, from a social media platform, who knows? And then you have the document ready to go. And Splice offered, they just go, look, practically speaking, these certified licenses from all the big label deals and all the big film companies that they work with are sufficient from everything that they've seen. They go, they get accepted. They are the proof of the sample being contained. We don't have a restriction on someone going and actually, selling the song that contains the sample. And so for me, I'm like, this is, quite frankly, fam, a huge win. And I'm kind of excited because, for when we started doing this and just making sure that these companies really do have your best interests, they're businesses. They're trying to make money. And so I'm really excited when companies are willing to kind of go that extra step just to exercise like transparency, good communication, to offer some additional info when maybe there is confusion. So I'm excited that they took the time to chat with us. Like I said, drop those comments down below if you want to see them update their terms of service. Give them a little encouragement. I'll see you guys on the next one.